in Lagos, if you are not a party in the matter, they won't allow you to enter the course because of the kind of matters that she handles. I think that is just our own preference. But generally, when it comes to certain dispute resolution mechanism, you cannot expect confidentiality. But when it comes to ADR, arbitration, mediation, and even negotiation, that consideration for confidentiality is very, very important. In short, it's one of the bedrock of ADR, where parties know that at the end of the day, by the time they come around to have their dispute resolved, they will not be hearing it in the newspaper or in any of the blogs because it's highly confidential. All right, then also, another thing to consider is cultural and commercial dynamics. There's some instances where you know that, okay, this dispute, because of the cultural belief of this group of people, there's the particular dispute resolution that is appropriate for it, or because of maybe the commercial nature of the dispute, you'll be able to tell, okay, this is the particular nature that will be appropriate for it. Then another thing that one also needs to consider, when you're looking at the right process, to employ to help your clients, resolve a dispute, or to help parties resolve a dispute, you also have to think of the enforcement part of it. How enforceable will the outcome be in this particular case? So that's part of the things that, elements that you have to consider when you're looking at the appropriate process designed for the different disputes that may come your way. Then another thing is the stages in designing an ADR process. So number one, I think it's still part of what I've mentioned, before. You assess the dispute. You try to see, okay, so where does this kind of dispute, where the particulars, because no two cases are actually the same. They may have similar facts and all of that, but there will still be some dissimilarities. So as a mediator or as an ADR practitioner or even as a lawyer, in assessing your client's case, please pardon me, I have a bit of cough. In assessing your client's case, you have to be sure, okay, let you look at the case holistically. Not every case that comes to you that you say, oh, let's go to court. Oh, no. You have to be able to assess it to know which one is the right, mechanism to adopt for this particular kind of case. I've had instances where they bring matters to our office and I look at it and we all sit down together and we're like, oh, this particular dispute, this is the right measure, the right way to go about it. We filed matters in court before that. Okay, maybe the client wants us to go to court. But of course, we would still want, because there are some clients that they can be very, how would I say now? They just believe that this is how they want their matter to be resolved. But as a lawyer, as an ADR practitioner, it's our duty to help them see, to see and assess whatever it is that is the issue, and see which of the dispute resolution mechanism will be appropriate for it. There's in some instances where it is litigation, then you go for it. There's some instances where it might be mediation, then you go for it, or even arbitration, depending on the kind of dispute. But of course, with regards to arbitration, you know that there must have probably been an arbitration clause in the contract, for example, commercial dispute. Okay, so the next point is also stakeholder identification. So there's some dispute that that these parties here on the other side, there's power imbalance, and that maybe your client doesn't really stand a chance when it comes to a particular dispute resolution mechanism. Maybe the person is well placed, and that this particular mechanism might not work. So you'll be able to really look at it holistically to know that, okay, at the end of the day, this is what would go in this particular case. In short, particularly in cases where there's a power imbalance. Then another thing is also the selection of the ADR mechanism, which is in line with what all I've been saying for now. You have to know the right mechanism to adopt for each of the disputes that comes your way, or that you have been briefed on. Then also the drafting procedures and timelines is also something that is very important for you to be able to design an appropriate process. So what is the procedure in this? What procedure There's arbitration, have to what procedures are in place for an arbitration to to occur, or what procedures are in mediation. All the processes is something that we need to be very familiar with as ADR practitioner, because that's what will give us an holistic idea of which one to advise our clients on, or which one, even for us as maybe as arbitrators or as mediators, which one should we go with regards to helping the parties settle their disputes. Also, in the process, another thing that is also considered is the selection of the neutrals. As we are very aware, neutrality is very key in ADR. It's one of the critical elements of ADR. The arbitrator or mediator must be seen to be neutral all through the process. So these are the things that one would also consider when structuring, an ADR process, or when you want to decide that, okay, this is the ADR mechanism I want to employ. You, of course, if you probably you're representing a client, you have to be very sure of the selection of the arbitrator or selection of the mediator. If it's someone that you know that this one will not be neutral or this one will be biased, you'll be able to know how to advise your client accordingly and go about ensuring that your client is well represented. Then also implementation and monitoring. This is very important. The whole process is something that should be seamless. It's not something that at the end of the day you get stuck and you don't know which way forward. From the beginning of the process, you have thought it out well to know that, okay, by the time I'm going into mediation, these are the phases, these are from this phase, this is the next thing. You are well aware, and in your being able to know all of these things, you'll be able to advise your client holistically. All right, so and the end of it, of course, you know that at the end of every ADR process, there will be a settlement, particularly a successful one. There will be a settlement or award enforcement. All right, so move to the next. Yeah, so we have the different ADR processes, and in short, in recent times, what people now do is ensure that they don't just leave the dispute resolution clause there, because so many people have gotten into trouble just because of the wrong clauses that was drafted in the dispute resolution clause. I remember a particular matter that when the client came to me, the whole sum was maybe about 2 million naira, and by the time I checked the dispute resolution clause, he had the appointment of 3 arbitrators for a 2 million naira claim. And I was wondering, 3 arbitrators, do you even know how much one arbitrator? So at the end of the day, of course, he couldn't go ahead with the arbitration because he was stuck. And if he even intends to do that, the party on the other side, or maybe he intends to now go to court, the party on the other side will be quick to say, oh, we have an arbitration clause that should be explored first before we go. So what people are now doing is, and particularly legal practitioners, when they draft agreements, they make it a multi-tiered phase, in the sense that they would put it there that at this stage, when negotiation fails, then we'll go to mediation. When mediation fails, we go to arbitration. And it's very important that as a practitioner, you know the right words that goes with a particular transaction. For example, you cannot be putting arbitration clause in a tenancy agreement. Tenancy agreement, or maybe the tenancy agreement, the whole money involved is about maybe just 700,000 naira per annum. And in the dispute resolution clause, we put arbitration. We put three arbitrators. Of course, it will not fly. If anything happens, the client will be stuck. Then another point is, in recent times, there's this med-ab and ab-med model that has been adopted. Med-ab in the sense that parties would have agreed in their dispute resolution clause that they will do a merging of mediation and arbitration, or a merging of arbitration and mediation. And what that means is that they can switch between both ADR mechanisms in resolving their dispute. They're not stuck to only arbitration, neither are they stuck to only mediation. Then we have the online dispute resolution, which is also coming up, and I think is even becoming more, since the COVID period, many platforms are now offering such kind of services. We have people that have built up. It's not very common in our clime. Pardon me. It's not very common in our time, but in the Western countries, they have ODR mechanisms, particularly in their online stores. Like Amazon has its own, eBay has its own, even long before COVID. I know a couple of people have tried to, to put something like that together in Nigeria, but I think one of the issues that we're having is the ADR itself, even the physical one, people have not fully embraced it. So maybe sometime in the nearest future, OGR will become a thing. It's not like it is not a thing. It really is for those that know it, but it's just that it's not as popular. And I think as time goes on, the next 10 years, it will become a thing because most people now are doing transactions online. Some of us, we don't even go to bank as we used to back in the days because everything is now online. You want to buy something, you just transfer money from your account to the seller and they deliver and all of those things. So I know with time, people will begin to warm up to ODR. Then also escalation clauses in commercial contracts. So of course, it's very important that in commercial contracts, parties go ahead, to ensure that they are well covered. That if this phase doesn't work, this next mechanism should be adopted. So that at the end of the day, they are not stuck on just one dispute resolution mechanism. Also, there are benefits of having this layered dispute resolution framework in your contract. It's very, very important that, or your agreement, it's very important that you have it so that, like I said, at the end of the day, one will not be stuck, trying to know which of the dispute resolution mechanism to adopt after you stated just one particular one and it did not work. All right, so we'll go to the next slide. Okay, so the presentation is a two-part presentation: the process design aspect of it and the ADR infrastructure aspect of it. But before we go into the ADR infrastructure aspect of it, I want to ask if I've been able to at least explain that design process well, and if there are any questions before I go into the second phase of it. So please, I would like to know if there are questions, or maybe better still, maybe someone can just do a summary of all that I've said so far. Let's see who will be willing to, based on the understanding of all that I've said so far. Because I need someone to do like a recap, so that I'm sure that I'm not just talking, just rambling and nobody's getting what I'm saying. So please, can somebody just give a little summary of what he or she has understood from what all that I've said so far?
All right. Somebody wants to speak?
Okay.
Okay.
I think from the second slide or the third slide, stages of process design. Can you hear me, ma'am?
Yes, I can hear you clearly.
Okay. I think the item number 4, it says drafting procedure and timelines. I want to really know this item. Is it the mediator that does that, or together with the client? Because you were explaining that, and then I wanted to ask that question.
Okay, thank you so much for asking. All right, is that all, please?
Yes.
Okay. All right, thank you very much, sir. But I didn't get your name.
Okay, my name is Akko Elias.
All right, thank you, Mr. Elias. Thank you. So, like as I was explaining, it's not just for how do I put it now? The process is not just for an individual. because along the line, I'll still talk about the different infrastructures, and if time would permit, I would go into each of the institutions and how they go about, their process. So basically, what this whole class is about is to just show us an overview of the structure of what goes into, what ADR institutes, what they do. And of course, I can't go into everything. It will take like God knows how many hours. But I have to start going into what LMDC does, what mediation, multi-court houses does, what Shati does, and all the various institutes that we have locally, not to now talk of those that we have internationally. So drafting procedure is part of the process of ADR. It's part of the design, how the process will go. Like I mentioned, for example, arbitration process now. How the process will go is part of is something that should have been envisaged, that a counsel would be familiar with. It's not that when you now get to the maybe, for example, you are representing a client, and it's when you get to the tribunal that you now start trying to think of, what am I going to do next? What should we do next? And all of that. So ahead of your client and ahead of the tribunal, you would have gone to make your own findings, to know the procedures. For example, you cannot be telling your client that, at the end of this arbitration, you get a settlement, because you know that arbitration is award in the end, not settlement agreement. So just having basic knowledge about all these procedures is very, very important, and also the timelines. For example,
All right.
Yes, please.
Let me also add my voice to that.
All right, sir.
We are talking about process design in stages in designing ADR processes. Now, we are not looking at it from the aspect of maybe you are doing a mediation session. If you are doing a mediation session, you may not necessarily be designing anything. Are we together? You will not be designing. You know the processes, you know the procedure you need to follow. You have been taught the processes and stages in mediation, isn't it? So, but this one has to do with, as trainers and people who are trying to master the art, somebody may say, okay, you have a school, and then you want to develop an ADR process for them, right? So they said, you go to the school and assess the disputes. What are the kind of disputes they have? What is the nature? Is it between teacher or students? Those are the things you are going to ask. Then, who are those involved in the dispute? Those are the stakeholders. You need to know those things before you can be able to design a process, right? Selection of ADR mechanisms. From what you know, is it negotiation that will serve? Is it mediation? Is it hybrid processes? Is it met up combination of the two? Which one? So those are the things we are going to be looking out for. So the question you are asking, drafting procedures and timeline. Drafting procedures and timeline. Now, if you are the one designing the process, if you are the one designing the process for them, this school, having assessed the stakeholder, the disputes, you have looked at the process you want to, you will now come to the drafting procedures and the timelines. Let's say if a dispute occur, within 5 days or 10 days of the dispute occurring, the student or the teachers will report it to so person, isn't it? Not just to go, you don't just go to anybody or go to the principal. You go, maybe you have a desk officer or a dispute resolution officer. You go and report it or put it in writing within 5 days. Within 2-3 days, they will escalate it to their management, or they are going to appoint a panel, or they will set a panel that is going to listen to it. So you have to put timing to everything that you are doing. You can't just say, if you have a dispute, just report it. You are the expert now. You are now designing a process. If there is a dispute, you are telling them the procedure they are going to follow. So when you file the complaint, they are going to escalate it to the person who is going to go through it, understand the nature of the dispute, then assign a panel of neutrals or assign it to a particular mediator or somebody who will assist. And you have to put time within 3 hours, within 4 hours, within 1 day, within 3 days. So that is timeline that they are talking about. And so you see the
Hello? We can't hear anymore. Hello? Hello? Please, am I being heard? I can't hear anymore.
Hello?
Hello? Hello?
Yeah, we can hear you. We online can hear you.
Oh, okay. So I think we lost those in the physical class.
Yes, yes.
How can we reach them now?
They will get back to us.
Oh, okay. So the thing is, they may not even know that they've been logged out.
Oh, okay. No, they should know.
Oh, okay. All right. So we just wait. Oh, they are totally out now. Even the other settlement house count is out.
Which
So
one?
you know, this there was still another one that was logged in. There was a settlement out logged in on this
Oh,
Zoom call is out
okay.
now. So we'll just hold on
Okay.
for a while. I think it's from their end.
Yes, let's just hold on.
All right. So okay, from those of us online as well, do we have any questions on what has been discussed so far?
Well, for me, I think I had one question where you were talking about is it on this hybrid something?
Okay.
The hybrid and multi-tier ADR process.
Yes.
I just need more explanation on that. What
Okay.
actually it means, the hybrid and then the multi-tier
Okay.
ADR process. Yes.
Okay. So basically, when he talks about hybrid, like what we are having now, it's online. So in
Okay.
some cases, there's some cases that they may start online and go into physical meetings, or
Okay.
they may start. They can have an hybrid of both online and physical ADR. For example, maybe a mediation, you know,
Okay.
or arbitration. You know, they can
Yes.
make provisions for maybe online to be online and mix it also
To be
with
physical.
physical.
Just like we are
Exactly.
having the training now.
Exactly. That's the hybrid part of it. Then the
Okay.
multi-tier part of it is now, like I was explaining, people are now getting better informed to know that, okay, so that they are not stuck, because once you have an arbitration clause in a contract agreement, you have to do the arbitration first before you go to court.
Okay.
You understand if there's any issue, with regards to the arbitration, but arbitration first. But now, people are now understanding that part. So they include not just only arbitration. So what is called the multi-tier clause is now, for example, you can now say, okay, the parties will negotiate where there's a dispute. But I'm talking about the dispute resolution clause now. Now, when there's a
Yes.
dispute, the parties can, meet within number of days that the dispute has arisen to negotiate. When negotiation fails, then they go to mediation before going to maybe arbitration or going to court. That's having a
Okay.
multi-tiered dispute resolution clause.
Yes. Okay.
Yeah, so that's what that's about.
I understand. Thank you.
You're welcome, sir.
Loma, are you with us?
Yes, I am. Okay. Can you
Okay, I
hear
think
me?
we have some interference. I think you can go ahead.
Okay, can you hear me clearly now?
Go
Can you hear
ahead,
me
yes.
clearly? All right.
Yes.
Okay.
Yes, yes.
Okay, so let's move on then. Thank you very much. Thanks for reconnecting. So I was explaining that was the first part of the topic. So this is the second part, the ADR infrastructure. So what is ADR infrastructure? It refers to the institutional, legal, and operational systems supporting ADR. And I wrote here that it also includes physical, legal, technological, and human resource structures, which are essential to effective and sustainable dispute resolution systems. Okay, so we go forward now. We look at the different components of ADR infrastructure. There are different aspects to it. We have the legal and regulatory framework. We have the ADR institutions and the ADR centers. We have the qualified neutrals and practitioners. That's ADR neutrals and practitioners. We have, oh, sorry, I put that into places. We have training and accreditation systems. Then also we have technology and digital platforms. And lastly, we have the funding and the administrative support. So I'll just go into some of them during the course of this training. Let me go. Okay, so for the legal support, legal framework supporting ADR, we have the national legal framework, and that includes our constitution. Of course, we know that based on our constitution, everyone has a right to be heard. It's part of the fundamental human rights, and if you have a right to be heard, you cannot be that right cannot be restricted in any way. So and that's another beautiful that we've had, that we have been longing for over the years. We had the in 2023 the enactment of the Arbitration and Mediation Act, the very first act in Nigeria that addresses the mediation, or it recognizes mediation as it were as a dispute resolution mechanism, which is an act that we are very thankful for. It just goes to show that even the government is now more interested in the promotion of mediation and its recognition as an ADR mechanism, amongst others. Over the years, there's always been arbitration. And I remember I used to joke with one of my senior friends, that really mediation is not the poor cousin of arbitration, like they make it look like, because it looks like it's arbitration that is shining and everybody, oh, I'm an arbitrator, this one arbitrate. But also, mediation is very, very key. And a while ago, I remember it wasn't sometime last year or 2 years ago, I ran a series on my LinkedIn page on the history of mediation. And surprisingly, I realized that mediation has even been in existence way longer than any other dispute resolution mechanism. It's something that has been extended for ages, and it's not surprising now that history is repeating itself and is now coming back to the fore. Having seen how other mechanisms have I wouldn't say they failed, but they've not been very sustainable. You can imagine you filing a matter in court, and just the preliminary stage of the matter, you're taking 10 years, because at some point the other side decides to appeal, and maybe you spent like maybe 2-3 years already in the High Court, appeals to Court of Appeal for another 5 years, and from Court of Appeal, one person is satisfied with the judgment, you appeal again to the Supreme Court, another maybe 10 years. And at the end of the day, you just realize that there's so much time that has been lost just on one case. So we're thankful for these enactments, and that recognition of mediation as an ADR mechanism, and also for the another legal framework that we are also happy to have, as a country, is the multi-door court houses. Their laws have really helped also to promote, access to justice, not just only mediation alone, even in other ADR aspects. And you see that it may not be so obvious, but there's been drastic reduction in the number of cases that fills our courts, and you see now at the end of the day, they're not even increasing the tenure of judges up to 70 years, and they are wanting. So when do they really want to rest? And that's because in an average judge has over 200 cases that he or she is handling. That is just one individual. So with the springing up of multi-door court houses in different states, I think as of now we have seen about 26 states, which is a very, very impressive one. We have, so it's not all matters that would end up being in court. Then we have the international legal framework that has bettered all these national laws. Of course, our constitution has been there from time. The ancestral model law, that one basically deals with arbitration, and even the New York Convention. But beautifully, we have the Singapore Convention that has now put mediation on the global stage. That mediation is no longer seen as a poor cousin of arbitration. That's just a joke on my side. Okay, so let me move to the next. Then we have the institutional ADR infrastructure. Like I just mentioned now, the court. Okay, no, I'll go to the first one on my list is the court annexed mediation system. I don't know if it's in all other states, but particularly in Lagos State, before you file a matter, before the matter gets to court, they will screen it first to see whether the matter can be resolved via mediation, so that before you even get into the court, they assigned to any judge, they would have screened it to see, okay, if the disputes here can be resolved via mediation, they send it to the LMDC. And it has really, really helped, because there are some very frivolous matters that at the end of the day should not even come within the 4 walls of the court. So court annexed mediation system has helped, and that structure has been put in place, to help promote ADR. And also now we have the multi-door court houses where parties can easily walk into. Even this court annexed mediation, there are instances where after parties have commenced proceedings in the regular court, the judge can still refer the parties back. I remember one of the matters I was handling a while ago, and you know how the judicial system is. Once the judge retires, you start de novo, and that was exactly what happened in this particular case. We had finished trial, we had done written address, only for judgment to be delivered, and the judge retired. So they had to reassign it to another judge, and we had to start all over again. Of course, the judge didn't consider the fact that if trial had already started, she still sent us back to the multi-door courthouse to see whether the matter can still be resolved, amicably. The matter would have been resolved, but unfortunately, the claimant, being a government parastatal, we're not willing to part with any sum as compensation. So we are back in court now. In fact, they've given us trial dates. By September now, we start trial all over again. Trial that we have completed as far back as say 2000, 2020, I think 2020 or there, 2021 or thereabout, that we had concluded just because the judge, retired. So issues like that we see how this ADR, there's so much echo. I think it's better now. All right. We see how the institutional ADR has helped and is still helping in many ways. Then we have the multi-door court houses that parties can now even walk into to have their matter resolved without coming to court. Then also, and in some states now, for example, in Lagos State, just to encourage people, to embrace mediation, we have like settlement week where you can just walk into court freely, free of charge to have your matter resolved. But even at that, it's very easy. Change is not an easy thing. We still have many people that still do not believe in ADR, despite all these freebies that they are getting. Then we have arbitration centers, like we have Shati'S now. We have different ADR centers. We have a mediation center. There are some centers that are just basically for mediation. In short, we even have individuals now. So this process design and infrastructure, this particular training now is, for example, maybe you have you have a passion to run an ADR center. It will come in handy for you to know how to put a structure to it. So we have ADR centers, ad hoc ADR and mediation centers that are springing up because we need so many of them. We need so many of them. Then we also have professional bodies and associations that already in their association, they have a dispute resolution mechanism that when an issue arises, easily they can just employ their ADR what's it called now, system that is within their association. I remember a while back, just about a week or thereabout, someone reached out to me. She worked with the UN and she had one or two issues and she just needed guidance. And so she consulted with me. And, at the end of the day, she even realized that for all her fears, there was an ombudsman that was already put in place, within their organization to help resolve the issue. And they would even assign someone to her, to guide her through the process. So we have organizations now that they are welcoming and ADR mechanisms rather than having to, escalate matters, go to court, fight it out, become enemies at the end of the day, So you really don't have to burn bridges. And that's one of the beautiful things about ADR. Then another thing is, role of universities and training institutions. So we have different training institutions like Shati'S that is coming up now, to train people and even create more awareness. And now, during our own time, ADR was not a thing. So it was not even a course for us to pick as a choice to offer in university. But now, we see more universities, embracing ADR. And some institutions, they even go as far as training people right there in their schools and even in law school. I think ICMC is doing one of those kind of programs, for students. All right, so we move on. All right, so this is another aspect of the infrastructural design for ADR. We are in an era where everything is becoming digitized. So we can't just play and just hold our hands and assume that, oh, I'm not a part of this generation. It is their generation. As long as you're still here, you're still very relevant here. As an ADR practitioner, it is very important that you also know about ODR, that's online dispute resolution. I think a while back, it was not 2020, I had my certification, with Lagos Multi-Law Court House with another international body. And the training was very fantastic. We just realized that there's so much going on out there that we here are not aware of. And that's just because we just feel that, oh, it's for them over there. But like I said, in recent times, things are changing. The world is a global village. Back in the days, you could bet if you want to make a call to somebody in America, you have to go to somebody that has a Nitel line in their house. I remember my dad then, we were fortunate to be one of those that had lines. So in the middle of the night, just people come around. They want to come and receive calls, from pardon me. They want to come and receive calls from their loved ones, that are abroad. But it's not like that anymore. Just on your own phone, you can call your cousin in Australia, your friend in Dubai, So the world has become a global village, as it were. And of course, in view of that, so many things are actually moving online. So now we have virtual mediation and we have virtual arbitration hearings. I even still had one last week, All we're doing, one of the parties is not based in the country. So of course, it has to be virtual. Then there's also the digital case management systems. We have different apps now that have been built to help to manage your case. I think in Lagos State now, they've gone off manual filing of processes. Everything is now digitized. If you want to file a process, you have to file it online. Then also we have AI assisted scheduling and documentation apps that all you just need to do is just to key in your details and it will give you a schedule of what your diary, usually what you would not ordinarily input in your diary. It can just, give you a schedule of all that you need to do, all your schedules, all your events, everything. You can have it just in one place on one app. All right. Okay, so at the end of the day, even though ADR is beautiful, ADR is wonderful, ADR is everything, yes, it has come to stay, but we still have the challenges. And one of it, which is a very key one, is number one, limited awareness and public trust. So I think for us in this time, because the adversarial method of resolving dispute is what we've been used to. So embracing ADR has not been very easy. I'm an ADR advocate. I use every medium I have, to let everybody know about ADR. But even at that, it's still not enough. People still don't trust the process as much as that. So it means we need more voices out there to propagate the gospel of ADR, because it's a major challenge in ADR. The fact that we have ADR mechanisms and the institutions and all of the process designs and all of that, you will be shocked that even some of your family members, they don't even know anything about ADR. So you that you are aware of ADR now, what are you going to do about it? So that is where it starts with. It starts with you, it starts with me, it starts with every one of us here, to ensure that people are aware of ADR. So one of the challenges is that limited awareness. Then number two, inadequate funding and facilities, which is very true. Unlike outside the country that they get funding for many things, as long as it is going to work, you see people that they are willing to put down their money, to help, run institutions and all of that. But we don't have that much here. So inadequate funding also can be an hindrance to the promotion of ADR, or even having I think some time ago, was not during the NSAS issue, Lagos multi courthouse, at least I remember that their own very well. They were going to go digital. They had bought computers, in the court, in the part of the building they were using in court. They had bought everything. I think the NSAS happened in October. They were going to go digital in November. And when the whole incident happened, the whole place was burnt down with all the computers. So you can imagine how much even till now, they still have not fully recovered, all that, happened around that time, So, and then also, another major plug in the wheel for ADR is enforcement difficulties. This one, it is not only ADR alone, even litigation. You have instances where the claimant, for example, maybe judgment, the creditor gets judgment in his favor and cannot enforce it just because there is no proper enforcement mechanism. At the end of the day, you just have your judgment on paper, and enforceability of it becomes another issue. So it's also very keen to ADR as well. It's not only litigation, it's and I think that enforcement issue is because we don't have enough laws to sanction those who err when judgments or awards are delivered, or when settlement agreements. But I think for mediation, enforcement is not such a big issue, in the sense that at the end of the day, parties willingly go into whatever settlement agreement, they put their all into whatever settlement agreement that they drafted at the end of the process. Then also, resistance from traditional litigation culture. This one is not even something that is an ASA. I once had a client that told me the matter was filed in 97 or thereabouts, and we were trying to resolve the matter via mediation. And I remember going with him for one of the sittings, one of the the proceedings, and as we were living there, he was telling me point blank that this matter, he inherited it from his father. His own children too, they will inherit it from him. I was taken aback. I was wondering, why would you talk like that? He said, yes. I said, but this is not the kind of inheritance that one should leave for your children. As in that really struck a chord in me that some people are just professional litigants. They just enjoy it. And so was the case of these our clients. But unfortunately, he passed. And at the end of the day, I knew what needed to be done. I just approached the family. Of course, they were even willing to settle. Obviously, the family said they were even tired of going to court. The other side too, they were tired of going to court. This was a 1997 matter. As of 2023, it was still lingering. It had gone to the Court of Appeal, gone to Supreme Court, it had come back. So everybody was already tired. The initial claimants and defendants, they've all died. Their children have taken over. So at the end of the day, I was able to, I'm thankful for the ADR training that I have had. So I was able to talk to both parties, both his family representatives and the other side. And that was how we settled that matter in 2023. Matter of how many years? So you can tell that there are some people that just adverse to any other, pardon me please, any other dispute resolution mechanism. Then also technological limitations. Cybersecurity is a major issue because as if hackers now, they're getting smarter by the day. I'm sure some of us, we've encountered such, even with just our WhatsApp. You see how they hack your WhatsApp and take over your account or your Facebook account. So that's another concern with regards to, the process building or, building a workable process or designing an infrastructure that would work for ADR. With regards to the ODR aspect, we have this cybersecurity issues and confidentiality. You'll be shocked that all your messages on WhatsApp that you're thinking they're encrypted, when push comes to shove and they want to get the real, evidence, they know where to go to get those data from your phone. So all those WhatsApp messages, emails that you think that they are very confidential, you'll be surprised how some people can go and dig some things out. So, and confidentiality, we know, is the bedrock of ADR. So these are part of the concerns the challenges that is being faced in this aspect of ADR process design and infrastructure. So the next slide, the recommendations. So what can we do? What can we really do at the end of the day? What can we do? What can be done to address all these concerns? What can be done to ensure that there are proper institutions that will promote ADR to the point that people would be willing to embrace it? So number one, continuous professional training. Learning should not stop. Just as we are having this training now, it's a very beautiful one. At least as we are having this training, more people are becoming aware that, there's something called ADR, there's something called arbitration, there's something called mediation. So continuous professional training is a very good one, irrespective of your age. And I'm happy that I even have older people embracing ADR because it is the future of dispute resolution, whether we want to accept it or not. Then also strong ADR legislation. Like I mentioned initially, I'm happy for the AMA that we have, but at the end of the day, it's not just even about having those laws, it's about being able to implement them and ensure that they work. Then also investments in digital ADR systems. As it is now, the world is a global village. There are instances where you would have transactions with people outside the country. So where there is a strong ADR, digital ADR system, it actually helps. There are instances where you don't have to travel all the way from Kaduna to Lagos to have your matter resolved. just because you can sit in the corner of your office, or you can sit in the comfort of your room, or even in your house, just as I am now, and have your dispute resolved online. So these are issues where, but money is needed. Investment in this particular venture is very important. Just like I mentioned that LMDC did a while ago, but unfortunately everything got burnt. We do not pray for that kind of incident again. I'm sure it was a huge investment that they made around that time, but that shouldn't now stop us from also going ahead to ensure that that kind of thing is put in place. For example, Shati, I'm sure Shati needs money. If you're an investor and you can just invest in it, and you will be surprised how much these institutes can grow, and how far-reaching it can be, and to be to the benefit of every one of us, knowing that we are all stakeholders in this particular institute. Then also public awareness, and like I mentioned, the public awareness as part of it in my previous explanation, it's very key. And stakeholder engagement. Some of us, people that know people that know people. Let them be aware that, there's something called ADR. I think, was it not last year's CIAP conference? Yes. That's Chartered Institute of Arbitrators conference. I was part of the planning committee, and we were to reach out to some meaningful people with the money so that they can sponsor the conference and all of that. And one of us that reached out to an SAM, he did not even know that there's something called CIAB. It was so surprising that SAN does not know that there's an organization or an institution in Nigeria that is CIAB, not even a Nigerian institution for that matter, a global institution. So as you're talking with your friends, maybe you go out, just talk about it. You'll be surprised that people don't even know about ADR. Then also institutional collaboration and standardization. It is very important so that the same standard is maintained all over, and there are no issues of maybe substandard what's it called now? Substandard service that is being rendered. So institutions can come together also to collaborate. I like the collaboration between Shati and the Kaduna Multi-Door. It's a beautiful one. It will also help to spread this gospel of ADR to different places. Excuse me, please. Then also user-friendly process design. This is very, very important. If you're designing an ADR process and people don't understand how it functions, then there's no use. So it must be something that is user-friendly. Let them understand that, this is the process, this is how it's done. When it is simplified, trust me, people will be willing to embrace it. Many people will be willing to embrace it. All right. So in conclusion, as I've put here, ADR remains critical to efficient dispute resolution, especially in the digital and global era. Effective ADR process design, it improves the success of ADR mechanisms, and a strong ADR infrastructure enhances accessibility and credibility. And in the end, sustainable ADR systems require innovation, regulation, and collaboration. So we come to the end of the presentation, and I welcome your questions.
Is the hand here? So do you have any question?
Yeah, questions, please.
Okay. Please go ahead, sir.
All right. Thank you very much for this wonderful presentation. I learned a lot. But I want to quickly ask, because I want to get why. Resistance from traditional litigation culture systems. I want to know, why will a lawyer or a legal practitioner be fighting against a very sustainable way of resolving conflict? Why?
Thank you so much for that question. You know, I didn't want to. Yes, can you hear me?
So that,
Yeah, I heard the question.
please stop sharing.
Oh, okay. All right. Okay, so I heard the question, and I'm happy that you asked that question, because at the end of the day, it seems I'm the one casting us now, but I actually won't mind casting lawyers. We lawyers, we are one of the clogs in the wheel of the progress of ADR. And I think this is just because most times lawyers sees ADR rather than what it is. They see it as an alarming drop in revenue. But things are actually changing, you know. So they see it as, oh, how will you show your clients that you are very effective? You know, because of that advocacy skills that we learned in law school, we want to show it. We want to show it in court that yes, you can slug it out. But at the end of the day, the 21st century client is not thinking that way. They want something that is fast, something that is quick, and would yield results. They're not even concerned about the process as much. So some lawyers, the reason why they would see ADR as something that is not bringing in so much money is because they are not actually seeing well. I'm sorry to say. Because a client that you help to resolve a dispute via ADR would also refer you to so many clients, rather than just holding on to one person just because of the money for filing, for court appearance. How much is that you'll be collecting from him every time? I remember a case that was once said during our training that there was a particular young man whose father owns a firm. And at the end, he came for mediation training. And at the end, a week after, there was this particular case in his father's firm that has been on for 30 years. And he was able to help the parties. Of course, he demonstrated what he learned during the course of the training and helped the parties to resolve it. With so much excitement, he picked his phone to call the father. Guess what? This sus, Keniko, I've resolved it. He said immediately, the father first of all turned off call and called back and said, what did you do? This same case that I have used to send all of you to school, you want to resolve it. So somehow, so it's obvious that the firm, they've been using that particular case as a cash cow. But like I was saying, 21st century clients are not like that. And the earlier we wake up to that realization, the better. Nobody wants to have their case in court for the next 10, 20 years without results. Now we are having a generation that they are result-oriented. So the earlier we wake up as lawyers, the better it is for all of us. All right, so I hope I've been able to answer your question.
So I think the last question would take with virtual. Mr. Paul his hand has been up. Please, if you can hear me, go ahead.
Okay, thank you very much. I want to appreciate our facilitator for this presentation. Very understanding, and thank you so much. Thank you very much. My question is on the challenges you are talking about federal process design, and one of it is limited resources and facilities. Now, where resources for who and for what, and then what kind of facilities do we need to in the design process? Thank you.
So sorry, the line is breaking. I didn't hear you clearly.
Okay. What I'm saying that in some challenges you mentioned in this thing is we have in and facilities. Now I'm asking funding in respect of what, and then what for, and then the facilities. What kind of facilities that will enhance this AR process?
Okay. So, for instance, now, if you want to have an ADR institute, you will need to pay staff. You will need a building, at least an office space.
Yes.
You will need to furnish it. So, at the end of the day, when you don't have people that are willing to invest in it, then your dream may never really come to reality. So at the end, it's just like you wanting to establish an office. You have that idea, but you don't have the funds. So imagine me now. I want to run an ADR institute, but I come to you knowing that you have the resources and you can invest in it, but because you don't believe in it, you are not investing. You're not willing to pass you the money, even though you have the money to give. So that's a typical example of the funding I was referring to.
Okay.
Okay, is there any other question?
Right. Thank you.
Thank you. Thank you.
You're welcome, sir.
Any other question? Comment? Any other question or comment? Okay, so let's assume that we all understood. All right. Moranike, thank you so much for creating time out of your busy schedule. And I can see that you are still having kata. You can see the commitment we ADR practitioners have to trainings. You know, so sometimes if it is ADR, you hardly see ADR practitioners rejecting opportunities to make impact, because just like the question that was asked, you know, the more you educate people about it, the more it becomes better for us. Because even among lawyers, you have people who are resisting ADR with all they have. You know, so if you educate lawyers, you educate professionals, you educate people, traditional rulers, we are all what? Building the future for ourselves. So when you have the opportunity, go and organize training in your mosque, in your church, in your community. Invite, you see all of these people, invite us. We can come around, you know, make sensitization, if they know and something happens and they need an expert, they will first reach out to you because you are the source. So that's what we are looking for. Thank you so much. On behalf of the management of Settlement House, ADR Training Institute, and the governing council, we want to say thank you so much for creating time out of your busy schedule to make this presentation and make impact on the trainees. Thank you so much. We look forward to seeing you more, and thank you. Bye for now.
All right, thank you very much. Thanks everyone for having me. All right, bye. Yeah.
All right, so I think we have come to the end of today. Online participants, thank you. We have come to the end of today's session. We can just—
Thank you, sir.
Yes, thank you, thank you. I've taken the pictures of those that are virtual. So we will just go out and just take a picture for the form. And then from there, we can now find our way. Thank you for being patient with us from the beginning to this point. Thank you.
Thank you. Good day. Goodbye.
Thank you and good night. Please, tomorrow, what time are we coming?
9 o'clock, 9:30.
Thank you, sir.
Yes.
Let's all have a nice time.